Good morning. A fantastic case wherein you can understand the concept of Evidence Act and the confessional statement being recorded as an FIR, the value of that, and the subsequent conduct of Section 8, admissibility of subsequent conduct of the accused under Evidence Act. All these have been, and apart from that, one more aspect was that the doctor's evidence is not evidence of facts, it's only advisory evidence. All these things we discussed. It's a very fantastic judgment, AR 2025, Supreme Court 3805. AR 2025, Supreme Court 3805, Narayan Yadav versus State of Chhattisgarh. What had happened, the appellant seems to have gone to his friend's house and wanted to enjoy drinking. He showed his lover picture to the deceased. The deceased said, she is looking good, send one day to my home. So that resulted the accused to cause death of the deceased. And thereafter he went to police station and lodged a FIR, narrating everything. And then trial commenced. The trial court convicted him under Section 302 IPC. On appeal before High Court has set aside, modified the conviction from 302 to 304 Part 2. So the Supreme Court initially, though they are acquitting the accused for all the charges, but they have not agreed for the charges being altered from 302 to 304 Part 2. They say Section 4 says death occurs without premeditation in a sudden fight due to sudden quarrel in heat of passion, provided offender did not take undue advantage of or act in a cruel or unusual manner. So this is what they have said, that we will discuss about in somewhere. Therefore, I will refer so many important subject of this area of the judgment, so that you can understand the Evidence Act very clearly. Then they say FIR is not admissible because it is barred by Section 25. FIR is admissible by accused if it is not incriminatory. Therefore, that evidence they are. Then they say evidence of doctor is not evidence of fact. The evidence of doctor is only advisory. That is also most important. Nowadays, doctors are giving some extraordinary evidence. Then the witnesses were turned hostile, therefore leading to recovery was not available. Section 8 was not available. Therefore, finally, accused was entered on acquittal. Now, I will ready to take you certain important paragraph. Then paragraph 17. The statement the FIR can normally be used only to contradict its maker as provided under Section 145 Evidence Act or under Section 157 of Evidence Act. In a criminal trial, however, neither of these is possible as long as maker of statement is an accused. That is most important. That is para 17. Then para 19. They say any admission defined under Section 17 of Evidence, there is no bar in using such admission against maker thereof as permitted under Section 21 of the Evidence Act, provided such admission is not inculpatory. So that was discussed. Several Supreme Court judgments were discussed. Then they say Section 25 of the Evidence Act is one of the provisions law dealing with confession made by the accused. So the law relating to confession is from 24 to 30 of the Evidence Act. And 162, 164 of Criminal Procedure Code, 17 to 30 of Evidence Act about admission, all that has been discussed at paragraph 22. Go through that also. Then they say, so they have Section 27(8) of the Indian Evidence Act. That is paragraph 10. Land Council appearing for state strenuously urged before us to take into consideration the conduct of the appellant, which according to me is relevant under Section 8 of the Evidence Act. He laid stress on the following. He went to police station, Panchanama was drawn, investigating officer visited his house, uncle, and pointed to the place where he had kept clothes worn at the time of. A blood stain was also found on the shirt of the. However, Land Council fairly considered there is nothing to indicate the blood stain matched with the blood group of the list. So they say all this is not discovery under Section 27 of the Evidence Act. So there should be time gap between the confession and the 27th recovery. All this has been discussed. Then most important aspect was the entire 300, 299 have been discussed under Section 35, 37. What amounts to murder, what not amounts to murder. All that you should understand. Paragraph 37 and 38, 39. There they say, and unless by exceptional, you can get diminishing sentence from 302 to 304, part 1 or part 2. That is available at paragraph 39. That is also helpful for you. See, they say Section 300 is a definition clause for murder, murder amounting to murder, culpable homicide amounting to murder. If the act by which death is caused is done with the intention of causing death, or the act complained of so eminently dangerous that it must in all probability cause death, or such bodily injury as it is likely to cause it. Therefore, some exception when culpable homicide is not murder under, we are concerned with the exception 4. They have discussed about exception 4. Finally, they are acquitted. So this much of judgment is most important, and kindly go through this. Then the question arises, today we are going to enjoy the inauguration of our annex building by my lords, the designated Chief Justice, our Chief Justice, Justice Mahadevan, M.N. Sundaresan, so many people, veteran judicial personals are coming, and I am also going to participate in that function. But unfortunately, at the last days, there was an approach stating that the criminal lawyers are excluding. There is no opportunity for the criminal lawyers to learn civil cases, all these things. I am not agreeing with that. Multi-number of criminal lawyers are also, they are practicing in civil sides. The problem was, it is their anxiety, learning capacity, and once if you are very at home with one side of practice, you can definitely travel to other side of practice, whatever it may, original side, commercial side, IPL side, because you have a talent of interpretation, understanding the provisions of law, reading the statutory provision concerning with the subject. So all this would definitely help, and because it's not that it is too far away from High Court building. See, we are already walking to 20 kilometers per day within the building, and we are also driven to rush from High Court building to Allikulam building, High Court building, Singaravelar Maligai, and Service Commission building. All these things are the Egmore Court where serious cases are there, commercial courts are there, all these things are there. So after all, let that be so many area of chances for juniors being engaged and paid for following these cases. Money should be circulated. So I hope you understand this situation where I am not agreeing for that, as I did not agree for refusal to transfer High Court and opening another branch at Madurai. And I was the staunch supporter for the proposal, and I faced so many consequences. I was beaten, whatever it may be. Finally, what happened? Even I had spoken before the general body MHA that not only Madurai, there should be an High Court branch at Coimbatore also. There should be some distribution. Now see how many lawyers are signing from Madurai. All these things are there. This is judicial sanatana. Whatever it may be, now they have forgotten about that. All veterans, fighters. Then question arises. I will discuss about this tomorrow. Best wishes.